The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 904, coming to you on Monday the 2nd of July 2018. On this program, I will speak to you on the topic possessory titles and family property. But before getting into the topic, a few preliminary comments. Firstly, condolences go out to all those families which have suffered recent bereavements. And I wish to mention two families in particular. The family of our church sister, Ernestine Samuel, also known as Sister by all of us in church. In fact, it's only after she died I found out what her real name was. She would be laid to rest on Saturday, I think, at St. Elizabeth Cathedral in Belmont. And I also want to send condolences to the family of Mr. Robert Sandy, former senior bailiff of the High Court. He served as a bailiff for many, many years and was easily one of the most efficient bailiffs the system has seen. He is being laid to rest this afternoon. In fact, as I speak, I believe his funeral service is on the way. And to all other families which have suffered bereavements, my deepest condolences. In a similar vein, on behalf of Mother Karen John and the other members of the family of the late Patriarch, His Excellency Edmund Eardley John, who was laid to rest on the 24th, the family wishes to say thank you to all those persons who in so many ways sympathized with them during their bereavement and gave tangible assistance towards the holding of the funeral service. Special thanks to the two national leaders in Parliament who were present at the funeral service, the Prime Minister, Dr. the Honorable Ralph Gonsalves, and the Honorable Adam Eustace, former Leader of the Opposition, as well as other members of Parliament who were there and other ministers of government. Family wishes to thank everybody, too numerous to mention, who did so many things in ways small and large to cushion the grief they felt, and in some aspects of the matter still feel with the passing of our late Patriarch. I'd just like to announce to spiritual Baptists everywhere that the 49th service would be held on the night of Saturday, the 14th of July, at St. Elizabeth, and not Sunday as was originally contemplated. The 49th would be Saturday. He died on the 5th of June, and the 49th service will be held on Saturday night, the 14th of July at St. Elizabeth. You will be notified as to the precise time on a subsequent occasion. Excuse me, please. As I speak, and it's now shortly after 3 in the afternoon, I believe there is a national event taking place for which the public service was given a half day, namely the official opening of the Medical Diagnostic Center in Georgetown. let me congratulate the government of St. Vincent and Grenadines, and assisted by the government of Cuba, on the provision of that facility. Who knows, I or members of my family might even benefit from it. The published reports indicate that the facility was constructed and equipped at a cost of $22 million. That is indeed something. According to the radio reports, the proceedings will be carried live on NBC Radio and no doubt on the API program sometime in the week. We may be privileged to see some snippets of what would have taken place, but I could imagine the pride felt by the citizens, the residents of Georgetown and surrounding areas, to know that such a facility is right in their midst, as it were. And finally, for preliminaries, it remains for me to wish happy birthday to my wife, Mrs. Juliet Campbell, who celebrates today. Some years ago, when she reached a certain milestone and I indicated what it was, I got into hot water, so I'm not permitted to say what milestone she has reached today, except to wish her all the very best. And I also have to say happy birthday in advance to my sister in the United States of America, Claire Fairweather. She will be celebrating on Wednesday. So my wife is the 2nd of July, my sister the 4th of July, and guess whose birthday it will be on the 6th of July? Well, I wouldn't tell you, that will remain a state secret. All right, topic for the evening, possessory titles and family property. These days, every Friday, when the newspapers come out, unless the Friday is a holiday in the newspapers, whenever the weekly newspapers come out, at least one national newspaper would carry at least one advertisement on behalf of some person advertising that they have made an application for the grant of a possessory title deed on the Possessory Titles Act 2004 and asking the court to approve the application. The Possessory Titles Act specifies that that application must be published in the newspapers so that everybody would know about any application made by anybody for a possessory title deed. A possessory title deed is a title deed which you are asking the court to give to you based on the fact that you have been in adverse possession of a piece of land or property for at least 12 years before you brought the application in court. Now, most of you would have heard me speaking about possessory titles since the law was passed in 2004. So to most of you, what I am saying is nothing new, but always remember, and I always assume, that every time the law and you comes on the air, that there could well be persons hearing a program or hearing the law on you for the first time. And therefore, if I say things that you are tired hearing, bear with me, because somebody might be hearing it for the first time. Now, all laws have to be read with their qualifications, with their exceptions, so that in most laws you have the scenario where on the one hand such and such is the case, but on the other hand such and such is the case. And this is one of the reasons why I usually advise you, and strongly too, and repeatedly, that where you have a legal problem or where you have doubts, go and seek legal advice. Don't rely on what I say on this program, because I speak in general terms. Your problem would be specific to you and specific to the circumstances of your case. What I say is meant for general guidance, but if you have a particular grievance, or you think you may have a problem, or you are thinking about applying for a possessory title, go to a lawyer and let the lawyer know what your situation is, and the lawyer will advise you on the facts of your case as you outline them to the lawyer. As you outline them to the lawyer. So if you do not outline your case in a frank and honest manner, and you twist things up to suit your convenience, and you take liberties with the truth, in other words, to be frank, you tell lies, the advice you get from the lawyer would not be accurate, because it would be based on misstatements, on false information, and perhaps on lies. And in most cases, if the matter goes to court, your falsehoods would be discovered. I recall having done at least 2 programs in the past called Tell Your Lawyer the Truth, where I was trying to convince you that there is nothing to be gained by holding back information from your lawyer or twisting things to suit yourself. Lay the facts before the lawyer, even if you feel the facts are against you, so that when the lawyer gives you legal advice, it would be based on solid facts and not on twisted conceptions and things you have invented or things you have deliberately left out. Now, I make those introductory remarks because the topic for tonight depends on you being honest with the lawyer if you are thinking about applying for a possessory title. The topic of the program is possessory titles and family property. Therefore, if you have been occupying a property for more than 12 years, and you feel the time has come for you to get a title deed for that property from the High Court, and you decide to go to a lawyer to fix up an application for you, you have a duty to tell the lawyer in a straight and honest manner what are the true circumstances surrounding your possession of that parcel of land or that property. Because the law of adverse possession, which forms the basis of possessory titles, is very strict. And one of the things the law provides is that if the property you have been occupying and in respect of which you want to file an application for possessory title has been family property, in most cases you will not be able to obtain a possessory title for that property unless you can show that every single member of the family who would otherwise have had an interest is dead or has given you approval to take his or her share. Adverse possession means possession of property which is against the interest of the true owner or owners. You cannot have adverse possession if somebody has given you permission to occupy a property or a piece of land. That can be adverse possession because your possession would not be adverse to the interests of the owner. In other words, your possession would not clash with the person's interest. If I have a parcel of land and I'm going away, and I say to you, look, I want you to look after this land for me. You could plant whatever you want on the land. Whatever you reap is yours and so on. But when I come back, hand back over the land to me. I'm not going to charge you any rent. You just occupy it with my permission. I can stay away for 1,000 years. And when I come back, well, let me not use 1,000 because nobody lives for 1,000 years, okay? I can stay away for 20 years. And when I come back, I come to you and I say, okay, I'm now back. I want to regain possession of my land. While I am away, and you are occupying the land which I gave you permission to occupy, and 12 years pass, you can't jump up and go to a lawyer and apply for a title deed for the land I gave you permission to occupy, because your possession for those 12 years and for any amount of years I'm away is with my permission. So people who have permission to occupy other people's property cannot claim title deeds by virtue of adverse possession or by virtue of the Possessory Titles Act. Once you are occupying somebody else's land with their permission, you can't claim the land by adverse possession. You have to understand that. And when you occupy family property, even though no member of the family has said to you specifically, yes, you can occupy it, when you occupy family possession, the law presumes that it is with the permission of the other family members to whom the land collectively belongs. And if when you go to the lawyer for legal advice, you don't tell the lawyer the truth and tell the lawyer, look, it's really family property and I have been in charge, everybody has gone away, I haven't heard from them, they have written, the lawyer will say, never mind, you haven't heard from them for 15, 20, 30 years. Unless you can prove that they are dead and they have no children and no spouses who have beneficial interest in their estate, you still have to hold the land as the trustee for the other members of the family who are not there, who have gone away, who have, in other words, tacitly allowed you to occupy it. You know, they have given permission, even though they haven't said anything, even though they haven't signed anything to say, I am giving you permission, by virtue of being family members who are entitled to a share in the land, they have given you permission if they do nothing. So you can't claim a possessory title deed if there are other family members who really have a share in the land. Now, when I say family, I don't mean distant cousins. I mean people who can show that according to the laws, they are entitled to a beneficial interest in the property. Let me break that down against it. Beneficial interest means that they are entitled to a benefit from the land. In other words, they are entitled to a share in the land. And when I say land, I mean property. When I say property, I mean land. Therefore, let us say you have siblings, brothers and sisters. Your mother has died, your father has died. All your brothers and sisters go away, and they have gone away since they were young. And 30 years pass. You haven't heard from one of them. You still can't go and apply and say, you have been in adverse possession of the property. You have to prove to the judge that they have abandoned their interest in the land, and that is hard to prove. Because even if you prove they are dead, you have to prove that not only are they dead, but they had no children or spouses who are entitled to claim a share in what they died and left. So that many applications, to my knowledge, have been turned down by the High Court on grounds that not enough evidence has been given to show that the interests of the family members who are entitled to an interest have been properly taken care of, and that those family members have given consent. So that if you have brothers and sisters who are alive and you are in touch with them and they're overseas, you can get them to sign certain documents to disclaim an interest, to say, look, I am signing to say I want nothing from the property, I am handing over my share to you. And if all of them have appropriately worded statements, duly notarized and authenticated, you can then present that as evidence that you have been in possession of the land. In fact, you could then apply for letters of administration. And by virtue of all your other co-beneficiaries disclaiming their interest in the property, you would end up as the only person who can claim it. Now, if you don't tell the lawyer all of this, the lawyer can't guess what are your family circumstances. The lawyer will ask you, well, to whom did this land belong? You say, oh, well, my father, but he died long ago, and I alone have been living there. You have any brothers and sisters? No, not really, you know. I say, not really. No, I don't have any brothers and sisters. You're lying. But no brothers and sisters, you're the only one. The lawyer would probably advise you in that case, why don't you let us apply for a grant of letters of administration? And the law has been changed recently by the Chief Justice, saying that whenever you have applied for a grant of letters of administration, that is where somebody has died without a will, or whether you have applied for a grant of probate, which is when somebody has left a will and you are the executor, or standing in the shoes of the executor, that application also nowadays has to be advertised in the newspapers. And in every newspaper you take up these days, you will see that so-and-so is giving notice that they have filed an application for letters of administration to the estate of so-and-so who died on such and such a date. And the notice will go on to say anyone who has an interest or who wishes to make an objection can file such an objection at the registry within 14 days of the publication of that. So that these days you have to publicize applications for probate and letters of administration. Makes the situation much more expensive. Not only that, but some wickedly high fees, I say wickedly in inverted commas, have been placed on an application for letters of administration. Extremely high fees, so it's very expensive now, and those haven't been placed there by the OECS governments. They have been placed there by the Chief Justice of the OECS Supreme Court system. Because under the laws, the Chief Justice had the right to make probate rules. And the Chief Justice made rules some time ago increasing the fees, saying you have to publish and so on. It is now very expensive to apply. But it safeguards the public interest. Because some people in the past have applied for letters of administration when they didn't have any right to do so. But because they were not required to publish it, nobody knew. They would get a grant of letters of administration, it would be in the courthouse, nobody would really know. But once a grant is made, the law presumes that notice to the world has been given. So we get back to possessory titles and family property. Next week, I will deal with another aspect of possessory titles, because many people seem to think that all you have to do is to live on property for 12 years and then you go and apply. No. No, no, no. There are conditions that you have to satisfy before you can be entitled to receiving a grant. And you will be advised of all of that if you go to a lawyer and tell the lawyer the straightforward facts. Don't chinks, don't try to hold back things and feel, well, you're pulling a fast one, because ultimately you will be discovered. All right? Okay, so that is all from this edition of The Law and You. I look forward to being of further service to you next week, Monday DV, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC, and brought to you on SVG-TV as a public service.